For the state of Texas.
For the defense?
Valerie Fisher on behalf of the defendant, Your Honor.
And are you Melanie Flores?
Yes, ma'am.
Why were there issues with you downstairs?
No, they had the wrong person.
So Ms. Paez revealed that you assaulted and choked her while you were in a dating relationship with her, and that you also forced her to commit acts of prostitution.
Be brutalized.
What was happening with the court system, she knew how to pick up new felonies, but she's been missing since 2020. And I don't know why I shouldn't send her to prison. 9-8 State of Texas versus Melanie Flores. Stand right there, Ms. Flores. Could I have parties announced for the record for the state?
Ryan Grimmer for the state of Texas.
For the defense?
Valerie Fisher on behalf of the defendant, Your Honor.
And are you Melanie Flores?
Yes, ma'am.
Why were there issues with you downstairs?
No, they had the wrong person.
It was the wrong person, Judge.
Okay.
Yeah.
All right.
It's a
Thank you, Melanie.
Okay, great. Can I see the trial court certification, please? See, communication is key. It's very key. All right. So according to the plea bargain in this case, the fine was set at $1,000. The state was recommending deferred adjudication, and this was the rank concurrent with 609260. But also, if she failed to appear on time to her PSI meeting or sentencing at 9 a.m. or picks up any new cases, she's subject to the full range of punishment. So this was set on April 21st, 2020. We have not seen your client since 2020.
That's correct, Your Honor. We asked for some leniency for the fact that that was right when the pandemic shutdown occurred. My client was under the misconception that she didn't have to appear since everything was shut down, is my understanding. And the confusion just continued when I could not get a hold of her for financial reasons. She didn't have the same number or the same living situation. And it was just confusion from the pandemic on.
No, I have that on June 8, 2020. You weren't unable to contact her, but she's been gone for over 2 years. So at some point in time, she knew she had a court setting.
Correct, Your Honor.
It
was really confusion after. That's correct, Your Honor. She became aware through just public forums that the courthouses were shut down. Everything was shut down in April of 2020 and just didn't know when to come back.
Before we dive in, just a quick note. This commentary is created for educational purposes, designed to help those who may be confused or curious about courtroom processes. If you don't find it helpful, feel free to skip ahead. But for those who want a deeper understanding, stay tuned, it's about to get intense. This case revolves around a defendant who vanished from the court system for more than 2 years after accepting a plea agreement. The defense claims pandemic confusion played a major role, but the judge appears far more concerned with personal responsibility and compliance with court orders. What makes this case especially dramatic is that while the defendant says she didn't know when to return to court, prosecutors reveal she allegedly picked up multiple new criminal charges during the same period. That contradiction is about to become the centerpiece of this hearing. Was this a misunderstanding created by extraordinary circumstances, or a choice to avoid facing the consequences? The judge is about to make her position very clear.
All right, I understand your argument, but she's been missing since 2020. And I don't know why I shouldn't send her to prison.
Also, just for context, I think the agreement was if she didn't show up for her PSI, which obviously she didn't, even though we've had hundreds of defendants who have showed up for her PSIs and have gone to court. She also picked up 3 new felonies. That was the only reason she was brought back into custody, was picking up 3 new felonies and a misdemeanor. That's the reason.
And I will tell you, I don't accept as true the new felonies, but she obviously was arrested for new felonies. So even though she's saying that, telling you that she didn't know what was happening with the court system, she knew how to pick up new felonies during COVID. So it wasn't like she is somebody who's just staying at home.
We understand that, Your Honor. My understanding of the new felonies is there is a co-defendant According to my client, that is, largely responsible to what I don't know the extent of the new felonies. I only ask for the deference to the fact that her court setting was the day before the shutdown, and there was confusion, and I, just could not get a hold of her. Financial situation spiraled during the pandemic. That's all, Your Honor.
All right, thank you. The court is going to follow the agreement that you were reached, find you guilty, sentence you to 2 years in the state jail facility. There's $1,000 fine, time and money to run concurrent, give you credit for any time served. This is run concurrent with 609260. But you may not understand the fact that you're going to prison. You may not want to go to prison, but what I can tell you, the reason why you're going to prison is because of your actions. The complainant says you were upset because she was texting a male. You choked her, made her block the male's number. Then I have this forced prostitution that she's saying happened. So Ms. Paez revealed that you assaulted and choked her while you were in a dating relationship with her, and that you also forced her to commit acts of prostitution.
He brutalized 2 different women within a matter of months. He assaulted these 2 different women, threatened them both with a knife, choked both of these women. He could have killed both of these women offenses, and he's been convicted of a prior assault. And he's still not taking responsibility. He considers choking these women, threatening these women with knives, beating these women, just getting a little rough.
You Dane Cortez?
Yes, ma'am.
State, do you have any witnesses?
No witnesses, Your Honor. Our victim, or one of our victims, could not get a ride this morning, so I just have her victim impact statement to read.
All right, defense, any witnesses?
None, Your Honor.
All right, then the court will hear argument. State you're opposed to the applications. Why?
Judge, he brutalized 2 different women within a matter of months. He assaulted these 2 different women, threatened them both with a knife, choked both of these women. He could have killed both of these women, not to mention the fact that he's already got an extensive criminal history that includes both felonies, misdemeanors. He's already been to prison before. He's had he's had several arrests for prior assaultive offenses, and he's been convicted of a prior assault, and he's still not taking responsibility. He still says, oh, I just got a little rough with her. He considers choking these women, threatening these women with knives, beating these women, just getting a little rough. We believe that he's dangerous. He poses a threat to these victims and the community. So we would ask that you hit the cap of 10 years and sentence him to prison.
All right, defense.
Mr. Cortez wants to avail himself of any kind of rehabilitative assets that the probation department might have. The first 3 paragraphs of the TAP evaluation are quite compelling. He's had an extensive history of mental illness acting in conjunction with drug abuse and alcoholism. He wants to try to improve. He's asking the court to grant him 10 years of community supervision. And although the TAP evaluation is not a suggestion of the court granting probation, it is a suggestion that if you did, that it be inpatient treatment. I believe that the assets that are available through probation are more rehabilitative in nature. Yes, we do have facilities at the Texas Department of Criminal Justice that will also address his issues. But if you make this the tightest locked down probation possible, if Mr. Cortez fails to comply, he'll go to the Texas Department of Criminal Justice. He'll do his 10 years, but maybe he can benefit, maybe society can benefit from whatever treatment he would get up front through the inpatient program. Is it DDOF? I've got the acronym wrong, Your Honor, but you read it right there.
All right, anything you wish to say?
Yes, ma'am.
All right, let me have you raise your right hand. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, lower your hand, state your name for the record.
Cortez.
All right, and could you keep your voice up so I can hear what you have to say? What do you have to say?
I just want to first apologize to the victims in these cases and to the courts and my family. I want to say that I do accept responsibility for my actions and I've made some really poor choices. And I want to just ask for a chance of the future to make better choices. And I know like I should have been being a productive member of the community, but I was doing negative things and I was on drugs and I was living wrong and I was always doing the wrong thing. So I do admit that I have done wrong.
All right. Any questions from the defense?
None, Your Honor. I'll rest with his allocution.
Any questions from the state?
No questions. We're just still asking that he be sent to prison for 10 years.
All right. I have a question. Why should I give you deferred or probation?
Because I know I completed well, Your Honor, and I know
But here,
do.
but why do people need probation or deferred adjudication in order to behave appropriately in society? How old are you?
29.
Yeah. So I always read everything before I accept a plea, and I always read everything the day of the plea, just so I can refamiliarize myself with the report and make sure that I haven't forgotten anything. And I always read the PSI report. So there are a lot of things going on with you in this PSI report, and both parties said they had no objections to the PSI report. So I have a choking where the complainant says you were upset because she was texting a male. You choked her, made her block the male's number. Then I have this forced prostitution that she's saying happened. So Ms. Paez revealed that you assaulted and choked her while you were in a dating relationship with her, and that you also forced her to commit acts of prostitution. And then we have this whole incident where she says that you choke her. Then she calls her friend to tell her that you choked her. Then you pull out a pocket knife, and that you have her call a friend back and to say that she made it up. I understand that you have drug issues and cocaine issues, but I don't think drug issues and cocaine issues make you assault people. So why are you assaulting people? I mean, that's what I'm trying to figure out.
Your Honor, I definitely have.
I mean,
I know that I need help and I know that it's not right. And I just went through some losses and I was sporadic with my behavior and my mind was everywhere because I had like PTSD from going through certain issues in my past, and sometimes it makes me just over drink and I won't know what I'm really doing, and then I'll look back at what I did and I'll be like, oh, that isn't right at all. Like, and I'll explain that to you.
All right. Well, I will tell you, Miss Garcia is saying I have no problem with him applying for probation, but Miss Perez is saying that no, she wants you to go to prison. And mind you, I am objectively looking at everything. So I'm not on anybody's side. I'm not on the complainant's side. I'm not on your side. I'm just looking at things objectively and trying to make a determination on what's best for society and best for you. If there's no chance of rehabilitation, then that's an issue. Then you need to go to prison. You understand?
Judge, sorry to interrupt. I think Ms. Garcia actually said, I'm not okay with him applying for probation.
Thank you. That is correct. So Ms. Garcia is not okay with you applying for probation. Ms. Paez doesn't want you to have probation. And those are things that I consider, but it's not something where I say, oh, the complainant says they shouldn't have probation, so you're immediately going to prison. I like to hear everything and see what's going on. But I don't think there's anything that I can do to help you. There are some cases where people should go to prison. And I'm looking at your federal case, and you've already been to federal prison before. And I don't know that you learned anything from that experience, because I do believe that they give you opportunities to rehabilitate there. So I'm going to deny your applications and find you guilty. Would anyone wish to speak to the cap?
The state would, Your Honor. We would ask that you hit the cap in this case and sentence him to 10 years. Although it's being taken into consideration, you have the evidence that was attached to the plea agreement for the other case against Ms. Ella Garcia, where she was brutalized. The officers described all her injuries in detail. She was taken to the hospital. She was also strangled and threatened with a knife. She was assaulted. And then, as the court has before, for the prior criminal history of the defendant, he's already been to prison, didn't learn his lesson. He's been on probation multiple times, has not learned his lesson. He does pose a threat to these victims, and we think 10 years is appropriate given the circumstances of these cases.
All right, Mr. Montgomery.
As we often tell juries in their instructions in a punishment page, we're not to consider how parole will work. But we're not in a jury situation. And I think we all know that with this young man's previous criminal history, the Board of Pardons and Paroles is likely to keep him for a very substantial amount of whatever sentence you should pronounce. Judge, when he comes out, he's going to be on de facto lifetime probation. I mean, not really, but he'll be a habitual if he ever picks up another felony. There's another judge who used to say to me or to my clients, I can't order you to seek treatment once you're released from the prison, but you really need to do it. I think he was sincere in telling you that he wants to change his ways, that he realizes that what he's done is wrong, and that he intends to seek help. I would ask the court to sentence him to 5 years in the prison.
All right. Mr. Cortez, there is a therapeutic community at the prison. Based upon your charges, I don't think that you will be eligible for it, but I'm not 100% certain of that. I cannot demand or force them to place you in the therapeutic community, but if you would like to be considered for that, I can request it. It doesn't extend the length of time you're in prison, but that may be something that can help you change your life.
Mhm.
So would you like me to request the therapeutic community?
Yes, ma'am.
All right, then. As previously stated, the court is finding you guilty. There's an affirmative finding of family violence. There's to be no contact with Amber Hernandez, Elia Garcia. Taking consideration 2021 CR 6392. There's a $1,500 fine, time and money to run concurrent. You credit for any time served, a request for the therapeutic community, and I'll sentence you to 9 years in prison. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it, and did you sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And because this is a felony conviction and an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
All right, good luck with you. We can go off the record. All right, here's the thing, Mr. Cortez. I know nobody wants to go to prison. I always tell defense attorneys and I tell prosecutors, you should always visit prisons. You should always visit the jail, because that's where you're sending people. And you need to know what it's like before you just send people there. So I visited several prisons. I visited several jails. And I know that you may feel some sort of way. You know, why didn't the judge give me a chance? But you need to take this opportunity to work on yourself. Don't get into any relationships when you get out of prison, because your life is not over. You still have a chance to better yourself. You're not like me. I have more of my life behind me than in front of me. I'm in the twilight of my life. So you have plenty of time to improve yourself. And when you get out of the prison, don't get in a relationship. And this is what I tell everybody. And people say, Judge, I can't believe you're saying that. Maybe you're belittling things, but I'm not trying to belittle anything. But this is what I've discovered. Get an orchid. Orchids take lots of patience. I don't know why my staff, they want to show love to me by giving me an orchid when they know I have difficulties with those. But I think they're beautiful. When you first get them, the flowers are on bloom. It's beautiful, just like a relationship. When you first get in a relationship, it's beautiful. Every bad habit that somebody has, you don't think of it as a bad habit. You think, oh, that's beautiful. The fact that they won't put the cap back on the toothpaste and they throw their phone. That's so beautiful. But then after a while, it starts nagging you. Same thing with an orchid. You get it, it's beautiful. Then the flowers fall off. And guess what? It takes a while for them to come back. So get an orchid. When the flowers fall off, if those flowers bloom again, you may be ready for a relationship because they require patience. You understand? All right. Now the state is going to read to you a victim impact statement. Just internalize it. It's going to be respectful. Okay. All right. Good luck to you.
I'm no longer holding on to what you did to me. I'm deciding to move on with my life. Knowing you has taught me a valuable lesson, and now I'm so much stronger than I was when you first met me. And that's something that no one can take away.
This case ultimately came down to accountability. Melanie Flores entered into a plea agreement that required her to appear for court-related obligations and avoid additional legal trouble. According to the court, neither condition was met. While the defense argued that pandemic-related confusion contributed to her disappearance from the court system, Judge Boyd found that explanation difficult to accept, particularly after learning that Flores had allegedly accumulated multiple new felony charges during the same period. As a result, the judge followed the terms attached to the original agreement and sentenced Flores to 2 years in a state jail facility along with a $1,000 fine running concurrently. This case serves as a reminder that plea agreements are not simply opportunities for leniency. They are legal commitments that come with responsibilities and consequences when those responsibilities are ignored. What's your opinion on this case? Do you think the judge's decision was fair, or too harsh considering the circumstances? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.